And welcome back to the Senior Hour right here on your hometown station, AM 1220 KHTS. Temporarily, I'm your host, Alex Urbina, for the day. If you have any questions, call us at 298-5487. Today, we're talking to Randall Kaiden. He's an attorney at law for the Elder Law Group. Give us a call again at 298-5487 if you have any questions. Randall, you're going to talk to us a little bit about IRA retirement trusts.
Yep.
And you have your tagline here, the ultimate legacy for your loved ones. What does that mean?
Yeah, so retirement trusts are one of my favorite instruments, and they've been around for a long time, but almost nobody's heard of them, and it's very rare that you find a practitioner that actually creates them. Now, it's interesting to look back before 2014, because when I would set up a retirement trust in the past, it was almost invariably under one scenario. And the scenario was where there was a husband and wife where they both had prior relationships and they both have children from a prior relationship. And so the fear amongst one of the spouses, let's say it's the husband, who might have a substantial IRA account, maybe a home, but not much else, and maybe she doesn't have very much as well, and he's maybe older, and the thought is, well, men typically pass away sooner than women, and what happens if I pass away and I just leave my IRA to my spouse, which is what probably 99% of the people out there do. Well, in this context, in a second marriage situation, the law states that the surviving spouse, once they roll over that retirement account, they can go ahead and name their own beneficiaries. So the fear has always been that if, let's say I'm the husband and I leave my IRA to my wife years later is going to leave that whatever's remaining in that IRA to her kids, and my kids are going to get cut out. And so we would create the retirement trust so that it's solidified that all the, let's say, minimum required distributions or even more distributions are coming out for the benefit of the surviving spouse. But once the surviving spouse is gone, whatever's left over stays in the family bloodline, and it goes to the kids of that person who had that retirement account. Now, I think that's a pretty rare situation, and that's why probably no one really heard about it but prior to 2 years ago. But 2 years ago, the Supreme Court heard a case called Clark versus Ramaker, and this changed the landscape for everything and everyone on this. And the reason why is because both under ERISA law, which is federal law, and under state law, it was always assumed, because it is written in there, that if you have a retirement plan, that it's protected in bankruptcy or it's protected from creditors. Well, we had Heidi Clark, who a number of years ago, she inherited around $1 million in an IRA from her mother when her mother passed away. And yeah, she was about 40 years old and her husband was around the same age. And over the 10-year period, that was in the early 2000s, her and her husband got, like a lot of people, into the real estate market, and they wound up going bankrupt. Long story short. And so they filed for bankruptcy, and their bankruptcy attorney had informed them that, well, don't worry, you still have this IRA that has $1 million in it, and so you're going to be fine. And so what happened was they went into the bankruptcy court, and the judge, first of all, the creditors were very smart in this situation. Today, being in the day and age that we're in, people have to be ultra careful. And this is a life lesson for what happened to Heidi Clark. What she did is, at the age of 50, she took some of the money out of that IRA and she went to stay at the Four Seasons in Hawaii with her husband, and she took pictures and she threw them up on Facebook, and the creditors, when they went into bankruptcy court, had pulled down those pictures and said to the bankruptcy judge, said, Your Honor, why should she be able to shelter this IRA when she's just taking the money out and going on vacation with it anyway? I mean, it doesn't make any sense. We should be able to tap into those funds if she's able to tap into those funds. And the judge said, makes sense to me. I agree with you. And the judge said, we're going to let the creditors go and invade the IRA. So this kind of sent the bankruptcy world in a tailspin, and they They appealed the case, of course, and it went up to the appellate court. And I'll try to make a long story a little bit shorter. It's the appellate court agreed with the district court, and they appealed for a writ of certiorari with the Supreme Court of the United States, which less than 1% of cases are actually granted per year. But the Supreme Court granted it in this scenario because the Supreme Court wanted to define what a retirement account was to begin with. And so the Supreme Court came up with this 15-prong test, and they said, okay, what is a retirement account? A retirement account is something that one puts their own money into for retirement. And they looked at Heidi and they said, Heidi, did you do that? Did you put your own money into this account for retirement? And of course she didn't. It was her mother's money. And they said, okay, a retirement account is something that you can't touch without penalty until you're 59 and a half. Well, they said, were you doing that, Heidi? Well, no, she was 50 years old and she wasn't paying any penalties, because when you have an inherited IRA, you don't have to pay penalties on it if you take the money out before 59 and a half. Another prong was they said a retirement account is something that you treat as being available for retirement. In other words, you're not using it until you're retired. And they said, was she using it before retirement? And they said, of course she was using it. She was using it to go to Hawaii. So on and so forth. She basically failed every prong of the test.
Wow.
And the Supreme Court said, well, guess what? It's not a retirement account in the hands of a beneficiary. So that was like, whoa, wait a second. Now what are we going to do? Because what happens most of the time is people will go to their estate planning attorney, and their estate planning attorney will say, well, this retirement account actually passes outside of the probate process. In other words, you just name who's the beneficiary on this account. And of course, people are going to name their spouse first, generally speaking, and after both they and their spouse are gone, they name their kids. So let's say they've got 2 kids, they will have their kids as the contingent beneficiaries. And it's been fine and it's worked, but it's not worked in the best way because of what's called the found money syndrome. So what generally happens, and this is straight from the IRS, and it's kind of shocking to me, but according to the IRS, most kids, when they inherit a retirement account in 12 months or less, they will take 100% of those funds out of the retirement account and use them for usually buying a car is the most common one. They keep driving by the Mercedes dealership and they say, I really want that Mercedes. They do that, and maybe they buy a couple other nice things, and they don't realize that the next April 15th, they owe this huge amount of tax. And oh, by the way, they lost all their tax deferral opportunities because they took the money out. Now, at least in the past, when you had this situation arise, it was thought that we had creditor protection. So if the kids, God forbid, got in a terrible car accident and they were sued for $10 million, it was thought that no one could tap into that IRA that mom or dad had left them. But with this Clark case, that's no longer true. And so when we're talking about retirement trust, we're talking about protecting people from both creditors and predators. And if you think about it, who's the number one creditor out there? The number one creditor out there is your future ex-spouse. I hate to put it like that, but the fact is that over 50% of the marriages in California wind up in divorce. So
I'm sure that's based on statistics, right? I mean, you're not making that up. You're just based on experience.
That's right. And so a parent leaves their son or daughter a retirement plan unwittingly, just thinking that they're doing a good thing for them, and lo and behold, they wind up getting a divorce. The child gets divorced, and somehow it gets commingled, or the judge somehow decides that particular spouse doesn't need as much of the marital assets, and boom, suddenly that IRA is
it's fair game, right?
It's fair game. It's kind of taken away from
especially if you have some bitterness in that divorce, and now that person has it out for, I'm going to get mine and you owe me, and now they're taking something that was gifted by a parent that worked really hard specifically for their child, and now they have to kind of divvy it up.
So it's really not a good situation, and we're just talking about the tip of the iceberg. I mean, really, there's so many different directions that liability can come from. Like I said, you can get in a car accident, you could get in a bad business deal, you could go through foreclosure, you could have a lot of medical bills. The number one reason for bankruptcy is because medical bills get out of control. So again, all of these retirement plans are fair game for the creditors and predators to tap into if there isn't some kind of safeguard there available. Now, to take kind of a step backwards, it's important to note, as we were discussing before, with living trusts, we've in the modern era, we've now have what's called conduit provisions. So really, we had three possibilities. Now we have three possibilities now, which we didn't necessarily have before, which was you could leave it outright to, like most people do, to their spouse and then to their kids, and they're able to get tax deferral in that way, but they don't have any creditor protection. And what's maybe worse is I see this a lot. I get the grandchildren of a predeceased child. They come and see me and they say, you know what, my grandfather left this IRA to both my uncle and my mom predeceased my grandfather, and the way the contract was written, it all goes to my father. And I know my grandparents would have wanted us, the grandchildren, to receive half of it. But there's nothing we can do about it because it passes outside of probate. So we have an accidental disinheritance in that situation. So leaving it in that situation, if you're not on top of your beneficiary designation forms, is dangerous in that manner, and also from the creditor protection standpoint. Now, with a modern trust these days, with what we call conduit provisions, we're able to stretch out the IRA, because the living trust, that is, can dictate exactly how the monies are coming out. But the living trust, again, is not providing asset protection for those beneficiaries. The only way to get the best of all worlds is through a retirement trust. And in a retirement trust, which is more analogous to, let's say, a corporation, you're setting up this separate corporation, which, by the way, has absolutely zero effect on mom or dad or grandfather during life. They can spend 100% of their retirement accounts. It only comes into effect once they are gone. What happens is that retirement trust becomes a conduit where the funds from the retirement plan, the minimum required distributions, or depending on how liberal or conservative we draft the trust, can flow through that retirement trust and can either be held in that retirement trust for the benefit of certain beneficiaries, or dispersed out to them. So this way, in that retirement trust, as long as it's held in that retirement trust, those creditors can't sue the beneficiary and get them. And the main reason for that is because the beneficiary, they have what's called a contingent distribution. It's not vested 100% yet. And that's because they could live, let's say, 50 years and stood there alive, but they still have some money in that retirement account. And who's the next beneficiary? The next beneficiary would be, let's say, their kids, okay? And because it might not 100% go to that child, a judge can't attach those retirement funds. So we've got the creditor protection in that retirement trust, and we're also able to dictate through the trustee and some professionals to say, you know what, let's have these funds come out more slowly. And what you have there in front of you is a little bit of the stretching and the mathematics. So a lot of times people will say to me, so big deal, I got the creditor protection, okay, my kid's responsible, I'm not really worried about it. And what's the big deal with the stretch out? Well, I've got a couple examples here. One is a little bit ridiculous, but the other one is extremely conservative to really nail this and bring the point home.
Let me just preface too, if you have a retirement plan that you will it to your kids, you wouldn't want to will something to them that's going to give them headache to the point where they get so disgusted that they just don't want to deal with it. It's almost like you're giving me more of a headache because you didn't set yourself up to really have it, be well. And as a gift, when it's gifting it over, you want it to be packaged in a way that it's set up to win, not turning it over to you, and then now us kids have to deal with this problem.
Well, you bring up a great point, but it's a little bit different. So, generally the kids or the beneficiaries are not complaining about the fact that they've received this inheritance. But what does happen a lot is, again, back to the spouse situation, is let's say your daughter inherits this $500,000 retirement account from you, and your son-in-law, her husband, he's kind of a little bit strong-willed and aggressive, and he really wants fill in the blank, and he's pressuring her. He's saying, you've got all this money in this retirement account. Let's just take out a little bit of that. What's $50,000? It's only 10% of it. Let's take it out so we can go buy that camper or whatever the case may be. And she knows that that's not something that her parents would have wanted, but she's getting all this pressure from him. But if it's just left to her outright, she's got no protection from that pressure. But if she's got the retirement trust in place that says, no, you don't even have the authority to do it, there's a separate person, a separate trustee that dictates how that money comes out, then they can go back to their spouse and say, you know what,
even if we wanted to, we can't, because it's not set up like that.
Correct.
So it's kind of like a faulty, a switch there to just, to protect you. From being influenced or manipulated, and where you don't have to deal with it. It's kind of like, hey, it's a safeguard to protect us, so when we really need it, it's there for us.
It's almost like you're taking the words out of my mouth, because one of the ways that I refer to this trust is a toggle switch trust. In other words, it toggles based on the situation that you're in.
Right.
So maybe kid is completely responsible and doing the right thing with these funds and such, and it completely makes sense to take out a distribution to buy, let's say, their first home, and they need that down payment for their first home, and the trustee can help decide to do that. But in another scenario where they're just being pressured by somebody to take the money out and having it spent in the way that, let's say, mom and dad didn't want it to be spent, we've got the ability to prevent them from doing that. So it is a nice little toggle switch there.
Nice. So in a sense, it's also set up that when you give the gift, you give it with its conditions to really support you in a way that they think is going to benefit you, not take you down a road where you now go and get into more debt and more creditors, and get taken away from you.
And it's really quite amazing, because actually most of the time when kids do inherit these retirement accounts, they have the best intentions. In other words, they might have a second mortgage, or maybe they've got $100,000 in credit card debt, and so they think, this is a godsend. I've got this, for example, $200,000 IRA. Let me go ahead and cash that out. So they go ahead and cash out the $200,000. They pay off the $100,000 in credit card debt, and the house needs some repairs. So they pay $20,000 for that, and they really need a new car, and they pay $40,000 for that, and this, that, and the other. And then we come up on the next year, and they talk to their accountant. Their accountant says, geez, you owe around $70,000 in taxes.
Oh.
And they say, what? And I didn't know that I owed $70,000 in taxes. And it's, whoa, yeah, exactly. They weren't smart about the way that they took it out, just because they didn't know. They didn't know any better.
So there's no advisor there letting them know, hey, when you take this out, and then boom, 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 they punch in the numbers and go, and show them on the calculator, this is a number you're going to have to come up with next year.
I think,
and then when they come for the next 50 grand, it's here's the net. So there's no one there kind of walking them through that process.
I think the important point to be made there is that we live in a world where you can't go to a jack of all trades. You can't go anymore to an attorney who practices everything if you want the best job done. You can't go to a general physician if you want surgery. You can't go to maybe even a certain type of mechanic on who knows one kind of car, but maybe not another kind of car. So the point I'm trying to make is that if you want it done right, depending on what you're talking about, you've got to go to a specialist in that area. Now, I have my master's in tax, and so I'm constantly dealing with tax issues. I'm currently the president of the National Academy of Elder Law Attorneys for Southern California. So I've been doing this. I started practicing in 1996. This is now 20 years. All I do is estate planning, tax, elder law, post-death administration of estates. So all these kinds of issues are issues that I deal with on a daily basis. So it's when a client comes in to see me, we're talking about that in the first meeting. Whereas if you're going to a generalist, it might just completely escape them. Just like this IRA issue.
Yeah, no, it makes sense that if you're going to go for something specific and you have a mindset or a vision, if you have a vision of what you want your kids to do with the money, or you have a certain vision of how you want to set yourself up to continue to live until your last breath, then you got to go to somebody that's niche specific like you are, And you can't just go, fly by the night person that understands the goodies to kind of generally explain it to you. But when it's time to now, utilize it or put it into effect, all of a sudden they're not around or they don't have the answers for you. That's what I love about what you got to offer, is that it's your niche, it's your specialty.
Yeah, and coming back to the mathematical example, I know most people don't like math, so I try to keep it simple here. But let's run some of these numbers here, and so
I'll tell you what, we're gonna leave that and dangle the carrot. So when we come back from the break, you can give them that knowledge.
Sounds great.
Stay tuned for more of the Senior Hour right here in your hometown station, AM 1220 KHTS. And welcome back to the Senior Hour right here in your hometown station, AM 1220 KHTS. I'm your host, Alex Urbina, and I'm sitting in studio with Randall Kaiden from Elder Law Group. And before we went on a break, you were gonna kind of go over some of the math. You were gonna run through the numbers of what having a retirement trust is versus leaving it to a beneficiary.
Yeah, so the first example, to kind of bring the point home of what it means to have tax-deferred investments versus taxable investments, I want to kind of give a ridiculous example, but it really drives the point home. Let's say you had $1 and you were to double it every year. Let's say you had an unbelievable financial advisor and you were doubling it every year for 20 years. The question is, after 20 years, after doubling it 20 times in essence, how much money would you have after 20 years? Well, the answer is you have a little bit over $1 million, okay? Now, let's take that same exact example, but now, every year after you've doubled that investment, you're taking out a third for federal and state income taxes. How much do you have after that 20 years? Well, the answer is you have around $35,000. So the difference between tax deferral and not having tax deferral is unbelievably huge. So that's the first point. But of course, now we can't really double our investment every year. So let's go to a more realistic example.
But I have a question regarding that.
Yeah.
So you defer the tax on the $1 million.
Yeah.
You're paying the tax on the $35,000.
Well, what happens is that anytime you receive income, you've got to pay tax on it.
Right.
We have 27 forms of tax in the United States, and we always think about income tax, although in my work I'm dealing with property taxes, transfer taxes, all sorts of taxes. So when we're talking about an IRA and we're pulling money out of the IRA, well, we have to pay tax on that. All the income that we've pulled out, we've got to pay tax on that. But as long as you're leaving the money in the IRA, and the great thing about IRAs and the reason why a lot of people have retirement plans in the United States is because it can grow every year without having to pay taxes on it. Even though it may be switching investments, you're getting dividends, interest, there's no tax while it's in that retirement account. So that's why we call it tax deferral.
Right, I understand that part.
Yeah.
So now, at the end of the 20 years, you have the $1 million. Now you want to pull it out. Now you're getting taxed.
Yes, so now you're going to be taxed at your tax rate. So whatever your tax rate happens to be. So let's just say you're in the worst case scenario and you're roughly being taxed on 40%, and for whatever reason you decide to pull out $1 million at one time, you're going to be left with something like $600,000 on that $1 million IRA versus the $35,000 that you would have had you been taxed to begin with.
So it's better to tax defer it while it's growing, so you get a big chunk, and then take your 40% tax bracket out. You still have half of a big chunk, rather than a third, because you were getting taxed on it along the whole process.
The whole way.
That makes sense.
Yeah, and to take it one step further, even better yet, is to just take out your minimum required distributions for your entire life. In this way, it becomes what we call a legacy trust or dynasty trust, because it could then be left to grandchildren or even great-grandchildren. So it can help people for many generations. That's an amazing thing. The other amazing thing about this is, and I've had clients tell me this, they say, you know what, frankly, my kids do not have enough money to retire on. Setting up this trust ensures that they will have a retirement account for their retirement. And so that's a very comforting thought for a lot of parents. Okay? So now to go back to the more realistic example, let's say you had a $200,000 IRA that you left to a child, and let's just say it was able to earn a 5% rate of return. But again, most kids will take that money out pretty quickly, in my experience, in 5 years or less, even though the IRS says it's in 1 year or less. But we know that in 5 years or less that the average person is going to pay $60,479 in taxes, which is going to leave them $141,000. So again, that's nice that they got the $141,000. They bought that nice Mercedes and paid off a couple of bills, but look at the difference. If they were to own that, get that IRA, and they had a 5% annual rate of return, which on average throughout time, 5% I think is very conservative and very doable. And you leave it to a child who's 40 years old, and if you use the IRS tables for life expectancy, that child is going to get $715,000 over their life expectancy.
Wow.
That number is a lot bigger than $140,000. Now let's use that same example and say we are going to leave it to a grandchild who's 10 years old, which a lot of people will do. Maybe they'll split up a retirement account, or maybe they'll leave the entire or a portion of the retirement account to a child or grandchild. But let's say you left $200,000 to a grandchild and it earns 5% over the course of their lifetime. That grandchild will have $1.9 million, over $1.9 million come out of it over their lifetime. Talk about a legacy. The conclusion is that with the retirement trust, the returns are 3 to 10 times larger on average than when you leave it outright to your beneficiaries.
That number, the 1.9, is music to my ears.
Yeah, wouldn't we all like to have
Well,
that?
when you talk about legacy, to me, that screams legacy. You know, almost $2 million to leave to my family is, to me, it sounds legacy. 600,000, 500,000. I mean, it's okay.
Yeah.
But you think about, you know, how do we really set them up to win? And when you're talking, this is what's going to my mind. I'm thinking to myself, we need to teach the millennials how to take care of themselves. We need to teach them how money works. We need to teach them how to protect themselves. And that's what you have in your back pocket, is the wealth of wisdom and all the expertise in this field. And if you're listening and you're a baby boomer or Generation X, you need to, teach yourself, but more importantly, you got to send your kids that are now in the working world to set themselves up to win. I think that's also handing down a legacy too.
Yeah, and there's also a flip side to that, and what we call parenting from the grave, which a lot of parents, frankly, they want to dictate how that money comes out. In other words, they sometimes say, you know, I want to use for education expenses, I want to use for medical expenses, so on and so forth, but I don't want them to go use it to go buy a Ferrari with it.
That's right.
Et cetera, et cetera.
And you got to set them up with advisors that are going to teach them that and kind of explain that. Even though you said it, sometimes it falls on deaf ears because you're put in the parent box, right? This is how we get a hold of you. If we want to call you, we want to call you at 661-247-8433.
Yes.
Again, 247-8433. You can find all the information on your website at KaidenElderLaw.com, or send you an email at Randall@KaidenLaw.com. Appreciate you taking the time for coming here.
Thank you so much.
Appreciate it. Thanks, Randall. This is your hometown station, KHTS AM 1220.